great to be back with all of you. It's noon here on the East Coast, and in New York City, it's unseasonably warm. It feels a bit like spring here, so we're getting a flavor of what's to come. We ask all of you to hang in there because it is yet February 25th, so probably a little bit more snow and tough stuff ahead. But we have a packed program, and as all of you know, we are working to keep it efficient with 30 minutes of your time rather than 45. So let me jump right to the agenda, if you don't mind, Kathy. We're going to start with Pete Jones, former host and frequent presenter who's familiar to all of you, esteemed labor lawyer, out of our Syracuse office, who's going to be speaking about the Federal Department of Education and its OCR, and a Dear Colleague letter that was issued addressing DEI, obviously in the context of all that's been changing with the federal administrations. There's a lot to keep track of. And so Pete's here for that. Alyssa Christian is back with us as well with a brief update on the Corporate Transparency Act, which has been a bit of a yo-yo, as it were, with various pauses and thoughts that it will not be enforceable, but evidently now it is again. So we want to make sure all of you are caught up on that. Chris Cruz Sierra here in the New York City office, around the corner from me, is here to tell us about the latest in congestion pricing. As we talked about before, it is a big ticket item involving federal approval. There's a lot of New York State's budget that is literally banking on it, and it is in the balance right now. So you'll get the latest. And then we'll close out with Brendan Goodwine, who that should be BR, and sorry about that, who will be talking about Eastern District of Texas sanctions and how that will all affect venue allegations and patent lawsuits. And with that, let me turn to Pete, who again is familiar to all of you. And we really look forward to, Pete, what you have to share in this constantly changing environment. There's much to stay on top of. Pete, the floor is yours.
Okay, thanks, Gabe, and good afternoon, everyone. It's good to be back here on the webinar. Obviously, there's been a lot happening in Washington and a lot of different guidance, executive orders coming out of Washington, D.C. That relate to DEI programs, non-discrimination obligations, and things of that nature. So wanted to spend a minute today talking about a Dear Colleague letter issued by the Department of Education Office for Civil Rights on Valentine's Day, February 14th. And I think even though this does relate primarily to schools and colleges, there's some insight in this into the administration's thinking about DEI programs and non-discrimination obligations. And so I do think that this is a topic that bears everybody's attention because it certainly signals and indeed states the administration's position on those issues. So what is a Dear Colleague letter? It's a statement of the position of the department, in this particular case, on the non-discrimination obligations of schools and other entities that receive federal financial assistance from the Department of Education. The single most pithy statement from the department's perspective of the Dear Colleague letter is that if an educational institution treats a person of one race differently than another person because of that person's race, the educational institution violates the law. So that is the simplest way to state the department's position. This is going to get a little bit more complicated when we get into the potential permutations, but it is very important, especially to our educational institutions, because the Dear Colleague letter does raise the possibility of the loss of federal funding. That federal funding could be pulled if the department's understanding of the non-discrimination obligations is not adhered to by our institutions. So where are we? It's worth just reprising a little bit how we got here. Students for Fair Admissions, SFFA. There were two cases that were issued in 2023 by the United States Supreme Court. addressing the use of race in college admissions under Title VI of the Civil Rights Act, and also under the Constitution to the extent we're talking about public entities, and indicating that race could no longer be used really in any fashion in the admissions process, unless the heightened constitutional standard of strict scrutiny could be satisfied, and finding in that case that that the objectives of the institutions did not satisfy that standard. If we think about Title VI, of course, which applies to educational institutions, to students, and prohibits, among other things, race discrimination, we also need to think about Title VII of the Civil Rights Act, which applies to employment decisions. And there's also a body of precedent there, which in essence holds something very similar, that race-conscious decisions are not permitted under Title VII of the Civil Rights Act. So the real question was, what does this mean? What do these principles mean? The SFFA decision and the court decisions under Title VII. And among other executive orders issued very early in the Trump presidency, on January 21, President Trump signed an executive order entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. I'm going to refer to it here as the J21 executive order. This Dear Colleague letter was issued, as I mentioned before, on February 14th. Then on February 21st, last Friday, certain aspects of the January 21 executive order were enjoined by a federal district court in Maryland. And so for right now, put on hold some aspects of that executive order as relates to DEI programs. However, the Dear Colleague letter, which was issued after the January 21 executive order, and is not enjoined by the court decision, still is out there and stating the department's position with respect to DEI programs. And so this quote here, which I have excerpted from the Dear Colleague letter, is a very broad application of the principles of the SFFA decision to a variety of things that go beyond admissions, okay, and go beyond hiring and the employment decisions, and speaks to a number of things that would be or could be part of DEI programs designed to be supportive, which are called into question by this Dear Colleague letter. And so you see the statement here that suggests a very broad application, a very broad interpretation of the SFFA decision, and potentially broad application of that as well. So the Dear Colleague letter takes the position on several of those features. For instance, what the Supreme Court talked about in the SFFA case was that although you could not use race for admissions, that you might look to other things that would illustrate the person's background that would not be race related, but could potentially indicate a broad background that would add to a diverse student population. And the Dear Colleague letter has taken a position on, the scope of that, that it cannot be a proxy for race, and stated pretty broadly, for instance, what schools might do in the area of essays and writing samples, and participation in extracurriculars, things of that nature. Basically taken a position that you need to be careful, even if you're not using a race-based criteria, that it's not a proxy. Again, the department's position at this point. So let's get to the final, basically the punchlines, if you will, from the Dear Colleague letter. All educational institutions were advised to do three things specifically: ensure that their policies and actions comply with the existing civil rights law, okay? cease all efforts to circumvent prohibitions on the use of race by relying on proxies or other indirect means to accomplish those ends, and cease reliance on third-party contractors and clearinghouses, aggregators that are being used by institutions in an effort to circumvent prohibited uses of race. Those things are taken right out of the Dear Colleague letter, but you can see that there is a great deal of interpretation that will have to go into, in particular, what items 2 and 3 mean and how they play out in individual circumstances. And as I mentioned before, the Dear Colleague letter explicitly states that if you do not comply with civil rights laws, you could face the loss of federal funding. Of course, the real question here is, how these principles are going to be applied. Okay, so let's sort of summarize where we are so that we can at least have a bit of an action plan. How do we proceed from here? Well, first of all, the Dear Colleague letter is not law, but interpretation. And it explicitly states that. But it is the Department of Education's interpretation, backed by, notice that federal funding is one of the levers that they could potentially exercise if they find that you're not complying with the federal civil rights laws. Although the January 21 executive order has been partially enjoined, it is clear that under any view of the law, not all DEI initiatives are going to be lawful, and not all are unlawful under the existing precedent. So the Dear Colleague letter states a position and singles an approach. What are we recommending? We're recommending that you review your programs and your program statements. Let's make sure we know what we're saying. Let's make sure that we're being careful with our language. Let's make sure that we're not conveying ideas or statements that we do not intend to convey. Okay, that's the easy part to state. It's much more difficult in practice. This idea of proxies, that should be reviewed as well to make sure that we understand what our language says and what our standards, how they apply and how they would be interpreted. The notion of third-party vendors and aggregators should also be reviewed. Again, the department has taken a position that those cannot be used to circumvent the non-discrimination provisions, but the real question is in the details of what is being done, whether those things are being used at all, and if so, whether they potentially are being used in a legal and permissible way. I would say that we recognize that this is very hard. These issues implicate values, morals, strategies that institutions have, adopted and looked at and thought very heavily about. They also implicate legal compliance, and they also potentially have financial implications. And so this is going to be a rather difficult endeavor, but one that we recommend that you pay some attention to, given the amount of attention that's being given to this issue right now. Dear Colleague letter, the last thing it says is that it will, within 14 days begin proceeding on this interpretation of the legal principles. And so we could expect to see some actions, as early as next week from the Department of Education. So that's the quick summary, Gabe. I'll kick it back to you. I don't know if there's any questions. I know we got a tight agenda, so happy to hang out and look in the chat and see if I can answer some as well.
That's exactly what I was going to say, Pete. There are a few that came in while you were speaking, and thank you in advance for addressing those. Very helpful summary, and as you indicated, things could start moving as soon as next week. So for all of those in the education world tuning in, as Pete recommended, it's time to take a close look at those areas that could be implicated. Let me move now with our agenda to our next speaker, and that is Alyssa Christian, who has spoken before on the Corporate Transparency Act. We are delighted to have Alyssa back. There is some movement. It seems like it's back on again. So we'd love to hear exactly what's happening. So Alyssa, the floor is yours. Thank you for keeping us all apprised.
Hi, everyone. So I am here again yet to give another update on the Corporate Transparency Act. As Gabe said, there is a new deadline and the reporting requirements have been reinstated. So on the next slide, I have just a brief reminder of what the Corporate Transparency Act is. We've presented on the CTA here numerous times, so I'm not going to go into much detail, but it is a law that requires most entities to file a report disclosing who its beneficial owners are. The new deadline that was announced last week is March 21st, 2025, so that's right around the corner. And any entity that's formed from here on out is going to have 30 days to file that report. And any company that has already filed its report will need to file a updated report within 30 days of a change that's made. So that's anything that you reported. If any of that changes, they have 30 days to update that report. So with all of this back and forth, I know many of you are wondering whether this reinstatement will last. And on the next slide, I outlined the possible outcomes. But in reality, the fact is this March 21st deadline is coming up very quickly. So it's unclear whether any of this is going to have any movement before that deadline. So it is likely that we are going to have to comply by March 21st. The first thing I have listed is a House bill that was passed with overwhelming support. This bill would extend the deadline to January 1st, 2026. The goal being the court cases that I'll go over in a second have not actually been decided on the merits. And so if the deadline is extended, it would give those courts time to determine the constitutionality of the Corporate Transparency Act. This bill did pass the House 408 to nothing, but it has not reached, the Senate has not reviewed and voted on it yet. And then of course the president would also have to sign it. So again, I don't know if that's going to happen before March 21st. There's also other bills in Congress to completely repeal the Corporate Transparency Act, but those haven't been reviewed or voted on yet. So again, not likely to happen before March 21st. As for the cases that have caused this back and forth, the Fifth Circuit, which is where the Texas Top Cop shop, and the Smith case are both, the Fifth Circuit will be determining the merits of the case sometime in March. And so we are waiting on a decision from them, as well as there's another case in the 11th Circuit, and that decision will likely come sooner on the constitutionality. Again, not sure which way it's going to go because there have been courts that have gone either way. So this main case that I have listed just last week or so, they determined that the CTA is constitutional. But again, as of right now, that's not really what the issue is. It's whether any of this is going to move the needle before March 21st. So on the next slide, I just have a final reminder that March 21st is coming up. If you are someone who has a business and you haven't filed your beneficial ownership information reports or even analyzed whether you need one, I encourage you to reach out sooner rather than later. Thank you.
Thank you, Alyssa. That was a useful update as to where things stand. And of course, we'll have you back if there's anything new to report on there. But for now, let's turn to Chris, who's down the hall from me here in New York City. And speaking of items that we've been updating regularly, Chris is here to tell us about the latest concerning congestion pricing. There has been some strong pushback from the current federal administration that we thought was worth noting, and just again, because it matters so much to the finances in New York State, which way this goes. Chris is here to tell us more about it. Chris?
Absolutely, Gabe. Thank you for including me this time around. And good afternoon to everyone. My name is Christopher Cruz, like Gabe said, an associate here in the New York City office at BSK. And today I'll be providing another update on the New York City Congestion Toll Program. Next slide, please. That went into effect on January 5th, 2025. There was some back and forth last year within the state and local politicians regarding the program, but it did go into effect. So just some quick background facts of the program that went into effect. It is a toll program that is effective 24/7 around the clock every day of the week. There are two sort of rate mechanisms. There's the peak times, and then there's the non-peak times or the overnight times. Peak times is anywhere between 5 a.m. to 9 p.m. on the weekdays, and non-peak times is going to be, or is, from 9 a.m. to 9 p.m. on the weekends. And during non-peak times, every individual who drives into the congestion zone gets a discount of 75%. And as you can see here, I've included a chart of the current rates. So as you can see, for example, passenger vehicles are charged $9 during peak times and $2.25 during non-peak times. Next slide, please. So last time we spoke, the discounts and exemptions weren't finalized, but on January 5th, they were. And so what went into effect is in terms of discount, we have the low income discount plan, which provides a 50% discount to low income individuals. There is an application process for those individuals. And what it does is, after the 10 first rides into the congestion zone, the individual is eligible for a 50% discount. Now, once the month ends, it kind of renews, and the individual will have to pay for the first 10 rides into the congestion zone of the month, the regular rate. The exemptions that went into effect, we have a couple. The first one being the qualifying authorized emergency vehicles. So those are your ambulances, fire vehicles, patrol vehicles. You also have your qualifying vehicle transporting individuals with disabilities. You have specialized government vehicles, school buses that are contracted by the New York City Department of Education. You also have commute vans licensed by the New York City Taxi and Limousine Commission, as well as buses, public buses. They have also implemented a tax credit for congestion relief zone residents. So if you live in the congestion zone, you are going to be eligible for a tax credit if you make less than $60,000 per year. Again, application process goes, you have to file an application and make sure that you are eligible and meet the criteria. And the credit goes to any toll that you have paid into the program. Next slide, please. Now, the MTA has been reporting the impacts of the program after its first month and a half. I know we're into month 2, but according to the MTA, there has been reduced congestion for commuters. And I will admit that sometimes I drive into work and my commute has gone down from 30 minutes to 15 minutes. There are faster travel times for buses and emergency vehicles. And the MTA has reported that it generated, in terms of revenue, almost $15 million from January 5th to January 31st, which is less than what they had anticipated in terms of net revenue. They had anticipated a revenue of $37.5 million, which is less than the $52 million that they had projected. Nevertheless, the MTA still projects that the program will meet its year mark of $500 million. But of course, there are some challenges down the road. Next slide, please. And that's what brings me here today. There has been federal involvement even before the program went into effect. The previous administration approved the program prior to the end of the Biden administration. But even before January 5th, the current administration, Trump had indicated that once elected as president, he would eliminate the program. And so indeed, on February 19th, 2025, the Trump administration revoked federal approval. And the federal government, to begin with, took the position that it needed to approve the program because the tolls touch on federal aid highways. So now that the federal government has revoked its approval, the MTA has filed a lawsuit in federal court, which leads me to the next slide, please, Kathy. On that same day when approval was revoked, the lawsuit was filed by the MTA and the Triborough Bridge and Tunnel Authority in the Southern District of New York. There are a couple of different arguments, some constitutional, some administrative, irreparable harm, and it was filed last week, so there hasn't been much movement. However, the New York State has taken the position that the program will continue in effect. And so once we have more developments, in the next few weeks or months, I'll be sure to come back on the program to provide any further updates. But that concludes it for my part. If you have any questions, please let me know.
Thank you, Chris. That was very helpful. And to be clear, the revocation is what's being challenged and whether the government indeed had the authority to revoke. That is the subject of these legal actions that are underway. And so we'll keep you all apprised. Let's move to our final speaker of the afternoon. That's Brendan Goodwine. Brendan has been on the program a few times over. And this represents a shift in topics for us, but a really important one. We try to cover intellectual property, including the world of patents, and the overlay with things like artificial intelligence as often as we can, because we know it matters to all of you. And Brendan's going to be touching on those themes in his presentation, which he promises to keep pithy. We know that we're nearing 12:30 and we want to end as close to on time as possible. Brendan, the floor is yours.
Thanks, Gabe. So yeah, the thing about patent litigation is these are expensive propositions, regardless of whether or not you're defending or asserting a patent. So it's always important to think sort of creatively about your goals and business outcomes. One of the areas that we've seen this become relevant is sort of the intersection between venue and Rule 11 sanctions. So, and there has been some movement, particularly a decision from Judge Gilstrap in the Eastern District of Texas that highlights this issue. So we'll briefly talk about those and sort of the implications. Next slide, please. So as you may or may not know, venue is a statute, a federal statute, statutory requirement. The general venue statute is 1391, but does not apply in patent litigation, in patent cases. Only 1400 Section B applies, which specifies you can only be sued for patent infringement where either you reside, which for the purposes of this means where you're incorporated, or where you have a regular and established place of business. Next slide. For venue to be proper, the courts have said that you have to have a physical place in the judicial district. That physical place has to be a regular and established place of business, and it has to be a physical place of yours, of you as the defendant. There are certain landscape issues, regular and established, has some case law defining what that is, but we're going to take a higher level look at this. Basically, what's important to know is venue is improper if even one of these requirements is missing, meaning you can't be sued in a jurisdiction where one of these factors is missing. Why is this important? We'll look at our next slide. For Rule 11 sanctions, this requires under the Federal Rules of Civil Procedure that anything filed with the court, including a complaint, any kind of motion, basically has support. That you've conducted a reasonable inquiry under the circumstances, and you're not just trying to waste time and money, or you're not advancing a frivolous argument. How this is relevant, so in the next slide, the court may impose sanctions on any attorney, law firm, or party that violates Rule 11. The goal of these sanctions are aimed at curbing abuses, so deterring inequitable behavior. But this can include attorney's fees and costs incurred for defending motions. So this brings us to the recent Eastern District of Texas case from the next slide, where the court actually found that the plaintiff did not essentially shore up their venue allegations correctly, and actually sanctioned the plaintiff, who was the same attorney filed both cases, and actually awarded sanctions to the defendant. So this is sort of an interesting case. There were no monetary sanctions in this case, but the plaintiff's attorney was sanctioned with significant continuing legal education requirements. So we've seen this in a couple of our cases in our practice, where clients or plaintiffs will file complaints that do not have or haven't investigated venue allegations. Some cases where they've actually copied it from previous complaints that were pre 2017. And in those cases, I think this is Judge Gilstrap's Rule 11 sanctions decision is an important reminder that Rule 11 can be a useful tool in combating and thinking creatively in some patent infringement cases. I see that we're a little bit over time, so I'm going to end it there and toss it back to you, Gabe.
Well, thank you so much for that quick summary, and remind everybody that slides will be available. So if you have questions about Brendan's content, let alone that of any of the speakers today, you can email them directly, as you see here, or otherwise review the slides. And I will be back with you again in a week's time as we flip into March, with February ending promptly. It's the shortest month, of course. Looking forward to seeing you all in a week. And in the meanwhile, enjoy the rest of what February has to offer. We thank you for your continuing commitment to the program.